Welcome to the Case Bank 7-Minute Update with selected cases from the case summaries added to our database during the month of August 2020. Case 1. The defendant complains that the Deputy DA improperly learned of his trial strategy by having his investigator look at jail visitor logs to see who was visiting the defendant. The Supreme Court rejects the argument due to the defendant's failure to show any prejudice. Case 2. Unless the original sentencing judge is unavailable, all petitions for relief under Penal Code Section 1170.95 should be assigned to the original sentencing judge. Case 3. Co-defendants seek severance of their penalty phase based on expert testimony that penalty juries always treat co-defendants the same and do not give each defendant an individual evaluation. Both the trial judge and the Supreme Court reject this argument. Case 4. The Miranda form used for the defendant was written in Spanish. It was not a perfect translation, but it was close enough. The Miranda warnings are not magic words. They are simply expressions of general concepts. Case 5. The drug analysis report prepared by the County Crime Lab is testimonial. Prosecutor only calls the lab supervisor to explain the results and to explain the testing. Supervisor had no first-hand knowledge of test results, which required subjective evaluation by the tech doing the test. Conviction reversed. Case 6. Even though the Child and Family Team Report under Welfare and Institution Code Section 706.5 and .6 is advisory only, it is still mandatory that it be obtained before the court issues an order removing the minor from his home. Case 7. Defendant seeks everything Facebook has on a victim witness to assist him in impeaching the victim and/or making a self-defense claim. Supreme Court lays out a 7-part balancing test and remands the motion to quash the subpoena back to the trial court. Case 8. During a consensual contact with the parked car, officer sees an open container of marijuana on the lap of the front seat passenger. Held, the marijuana seen is contraband and may be seized. Also, this is probable cause to search the rest of the car for more marijuana. Case 9. At night, officer comes across a parked car with 2 occupants inside. He pulls behind, parks, and shines his white spotlight on the car before approaching on foot. Held. Use of the white spotlight did not turn this contact into a detention. DCAs are now split on this issue. Case 10. Defendant's old murder conviction is set aside under PC 1170.95 and the defendant is sentenced to underlying robbery counts to credit the time served plus 2 years of parole. Defendant asserts his excess CTS should be used to reduce his parole time. Held. The court has discretion to use or not use excess credit for time served in this fashion. Case 11. After opening statement, Juror X tells the court that she knows a key witness by a nickname not used during voir dire. At the hearing, X says she knows, likes, and respects the witness, but can be impartial. Trial court held no misconduct, but excused the juror for cause. An alternate was seated. Upheld. Case 12. 3 weeks into trial, Juror X is dismissed for constantly trying to talk to fellow jurors about the case. Defendant wanted all the jurors X talked with also excused. Court found that they were simply being polite and passive and therefore could stay. Upheld. Case 13. Sexual assault victim refuses to testify at defendant's second trial. Witness is found unavailable. Defendant asserts that CCP 1219, which prohibits judges from jailing such a witness in an effort to coerce the witness to testify, is unconstitutional infringement on his right to confront witnesses. CCP 1219 is upheld. Case 14. If an adult is resisting being moved, no matter how intoxicated the adult may be, and no matter how beneficial the moving may be, it is kidnapping to use force to move the victim against her will. To download a PDF of all the cases added in August, or to download the entire 20,000 plus case database, go to our website at casebanklaw.com.